Recording in progress.
Iku Iluna, please rise. Ea ka aha o kolo kolo ki ike hano hano u a koa koa ho maila. This Honorable Supreme Court is now reconvened. Enoho ilalo, please be seated.
Please call the case.
SCWC-18-0000216, State of Hawaii, Department of Public Safety, Respondent Employer Appellant Appellee versus Ruth Forbes, Petitioner Appellee Appellant, and Merit Appeals Board, Sean Sonata, Valerie P. Pacheco, and Nora Nomura, Respondents, Agency Appellees. Arguing for Petitioner Ruth Forbes, Ted Hong. Arguing for the Respondent, State of Hawaii, Department of Public Safety, Deputy Solicitor General Siana Guilano, for argument on the merits.
All right. Good morning. Aloha, everyone. Our proceeding today is being broadcast live on our Judiciary YouTube channel as well as on Olelo. Counsel, are you both ready to proceed? Yes. Mr. Hong? Ms. Guilano? Okay. We've allocated 30 minutes for each side. Mr. Hong, you've asked for a warning with 10 minutes to go, so you can reserve some time for rebuttal. Ms. Guilano, we're going to give you a warning light with 10 minutes to go in your argument as well. Mr. Hong, please proceed.
Mr. Chief Justice Rectenwald, Associate Justices, good morning. May it please the court, my name is Ted Hong. I represent the petitioner, Ruth Forbes, who is present in the gallery this morning with her husband. It is uncontested that the petitioner was a civil service member who was excluded from collective bargaining at the time that she was terminated from her position at the warden at Kulani Correctional Facility on the Big Island. The two issues that we're presenting to the court this morning are one, whether the just cause analysis applies to excluded employees, and two, whether the Merit Appeals Board's decision and analysis was entitled to judicial deference. First, the just cause Constitution states that civil service is governed by the merit principle. The merit principle is defined in section 76-1 of the Hawaii Revised Statutes. In the Kono case, the Hawaii State Supreme Court used the merit principle analysis to come to the conclusion that civil servants can only be terminated for just cause. That's 85 Hawaii at page 68. Section 76-47E as an echo grants any discharged excluded employee the right to appeal to the Merit Appeals Board. As an excluded employee, she is governed or subject to the provisions in Chapter 89C, as in Charlie. And Section 89C-2 sub 3 states that any adjustment, which is defined as any changes in wages, hours, benefits, or other terms and conditions of employment, must be consistent with the merit principle, and their rights under Chapter 76 cannot be diminished.
Mr. Hong, isn't the most direct statute, though, that you haven't referenced yet, 7646, which specifically addresses discharge of an employee?
Yes. What I'm trying to do is show how the just cause analysis applies and then address actually 76-47 with respect to that provision about the policy, methodology, and administration in the second part.
But 76-46 specifically addresses discharges. And that's what we're dealing with here. Is that not correct?
That's correct, Your Honor.
Okay, so I guess I'd like to make sure that you address why just cause, which is not referenced in 7646, fits under that statute. I mean, that's a legislative standard for discharges. And so I'm trying to understand that your just cause argument within the context of that provision.
Right. So in terms of just cause, as we pointed out in the City of Seattle and Kelso case, it's a widely accepted practice with respect to public sector employment law. We would submit that in terms of first I think you have to look at chapter 76 and 89C in pari materia. And that's the point I'm trying to make. In 89C-6, it says this chapter takes precedent over any other legislation or any department rules, including the Merit Appeals Board's rules. And then if you look at the legislative intent with respect to what happened in 2000, Act 253, which the conference committee report appears at docket 83, appendix 7, PDF pages 5 and 6. It talks about there is a consistency and uniformity that the legislature was trying to reach with respect to collective bargaining employees and excluded employees. That led to Executive Order 03-01, which specifically stated that excluded employees could only be disciplined for just cause. That's the Record on Appeal, docket 85, appendix 9, PDF page 3. 76-47E states that the Merit Appeals Board can modify the department's decision, quote, if it finds circumstances require and may thereupon order such disposition as it may deem just. That language also appears in the Administrative Rule 14-25.1-4, X's and X-ray sub 2. We can all agree that the Merit Appeals Board does not sit in equity. It doesn't balance factors, facts, and claims or parties. Reading Chapter 89C and Chapter 76 in pari materia, the Merit Appeals Board does have the authority to modify a department's decision based on just cause. I would note Administrative Rule 14-25.1-4Y, as in Yankee, requires all Merit Appeals Board decisions to be made according to personnel law, rules, policies, and practices. Just cause is a long recognized practice.
Mr. Hart, what about the workplace nonviolence policy? That seemed to play a big role in the mind of the circuit court. Is that an example of a matter of policy methodology and administration that's left for the determination of the director and that therefore is sort of out of the scope of a just cause analysis? Or what's your take on the relevance of that particular policy to this case?
Thank you for asking the question, Chief Justice. Let me point out that with respect to ADM 08.10, that was never part of the record before the Merit Appeals Board or the Circuit Court or the Intermediate Court. And in fact, what the Circuit Court was citing at page 11 of its decision, which is at the Record on Appeal Volume 2 at PDF page 208, what the Circuit Court cites is actually a departmental summary of the rule. And at the hearing, the state of Hawaii, which has the burden of proof with respect to justifying my client's termination, stated that they weren't going to put that particular rule or policy into the record. And that's at Volume 7, Docket 46, PDF page 208, lines 9 through 17. After the hearing, the department submitted a memo to the Merit Appeals Board saying it would not submit Rule 08.10 that the court referred to. So what was being circulated or cited by the Circuit Court and then the Intermediate Court in its decision at pages 6 and 7 is actually just a summary that the department put together and submitted to the Merit Appeals Board. At no time was that rule entered into evidence. And I would point out that in the record, the only rule that was actually part of the record was ADM 03-13, the anti-discrimination policy. With respect to that policy, it states on the Record on Appeal, Volume 3, Docket 38, PDF page 168, it states that that's only a guidance. So one of the fundamental errors we have in this particular case with respect to judicial deference is that—
Just to come back to the prior point, you don't think that it's appropriate to rely on 8.10?
That's correct. I think the record is insufficient, and the record is actually deficient by choice. The state of Hawaii on 2 occasions had the opportunity to put put the rule into evidence, and they specifically stated they wouldn't. Now, we don't bear the burden of proof, and I know the question might come up, well, Mr. Hong, did you object at any time in the Merit Appeals Board hearing that this rule wasn't coming into evidence? And that's not our burden. They have the burden under the administrative rules to prove that my client's termination was justified. And instead, all they submitted were summaries of the applicable rules. And there was no circumstantial guarantee that that rule that they were quoting in this decision, and I think it's at, well, there's no guarantee that that excerpt, the summary, which appears at volume 4, docket 40, PDF page 18. That's the summary that the circuit court was citing, that the intermediate court relied on. But there's no guarantee throughout the whole record that that summary was accurate or a complete verbatim statement of the rule.
Counsel, in regard to these rules, when I was looking through the record, there was the letter September 2nd, 2015, which I believe was the due process notice to your client, setting out what the allegations and what the charges and what the policies were that she was alleged to have violated. And you had the allegation regarding to Mr. Castro and a reference to 8.10 as being the policy under which that charge was under. And I believe that became charge 25. Am I correct on that?
That's correct, Your Honor.
All right. And charge 2 was under 3.13 on the general harassment.
That's correct.
All right. And 8.10 includes an element of intent to cause harm. And that's what charge 25 was, correct?
That's correct. And it also states that it is a zero tolerance policy.
All right. And then the letter sent to your client from the department that sustained the charges, November 10, 2015, it sustained charge 2, and it also sustained charge 25. And charge 25 was the only one that referred to policy 8.10. Did I read that correctly?
That's correct, Your Honor.
All right. And then when you got to the Merit Appeals Board, charge 25 was not sustained.
That's correct, Your Honor.
And was that the only zero tolerance charge among all the charges that were presented to your client?
As I recall, I think the court is correct in its
All right.
summary.
So if that's the case, there was zero tolerance was out at that point. And the board went to its discretionary authority given by the legislature to modify the termination and turned it into a 60-day suspension. Is that what happened?
That's correct, Your Honor.
So what was the abuse on that by the board? Well, let me ask you, was charge 25, was the fact that it wasn't sustained, was that challenged on appeal?
No, we didn't challenge it. I would submit that
Did the state challenge it?
I believe it did. It
I
challenged.
didn't see that.
Okay, well, I thought they were appealing all the claims that the Merit or charges that the Merit Appeals Board.
I'll ask them, but I
Denied.
didn't see that in the record. I want to know if you saw anything to the contrary.
No, that was my impression. In terms of the question you pointed out in exercising its discretion, I would only cite to the court what is not cited in any of the briefs is section 26-5 C, as in Charlie of the Hawaii Revised Statutes. What that specific statute says is that any member of the Merit Appeals Board must have knowledge of public employment laws and prior experience with public employment. So I submit that in terms of judicial deference, this is a highly specialized board. This is not just a board or commission of people, lay people. They were well-versed in public sector employment law, and therefore they were certainly entitled to deference.
Was the penal code on sexual assault incorporated anywhere in any of these policies under which your client was alleged to have violated?
I'm sorry, Your Honor, I didn't hear the first
Was
one.
a penal code on sex assault, was that incorporated into any of the policies under which your client was alleged to have violated?
I don't believe so, no.
Do you know where the court got that from?
No,
The circuit
I
court
believe
when they
that was,
reviewed?
I believe that Judge Hiroka put that in sua sponte, and I think that in terms of his decision, it was primarily based on 91-14G sub 2, which talks about the agency exceeding its statutory authority. And that's where I think that when I read the opinion, it kind of hooks into reversing
Did the circuit court do that based on, didn't the circuit court refer to a zero tolerance policy?
Yes, Your Honor.
But according to what Justice Devens just asked, the zero tolerance policy charge was not sustained by the MAB.
That's correct, Your Honor.
And he did not, the circuit court did not have the authority to reinstate that charge, right?
No, it should not have been able to reinstate the charge. And moreover, one of the fundamental questions that I highlighted earlier was the rule was never placed into the record. I mean, all of you have done administrative hearings or other type of hearings in your prior lives. One of the first things you do is you put the statute or the administrative
Well,
rule.
I mean, this court can take judicial notice of administrative rules, right?
It-
So,
It can, but in this case, you have the state of Hawaii intentionally saying on 2 different occasions it wasn't going to put the rule into evidence or put the
but
rule.
does it really matter if the charge was not sustained?
It does from my perspective because the intermediate court overturned or affirmed the circuit court's decision to overturn the Merit Appeals Board's decision. So from my perspective, I'm looking like I have to swim upstream and fight the entire battle.
Wait, and just to be clear from the record, I mean, charge 2 was sustained. It seems to, it appears to arise from the same incident, right? It's the same incident.
That's true. And when you look through the list of charges, a lot of them were double charged. So,
Right.
I mean, it was very duplicative.
Right, okay, so, you know, whether the zero tolerance policy, certainly, at least in the documents that were referred to specifically, were referenced with regards to charge 25. Charge 25 and charge 2 arise from the same incident.
That's
Charge
correct.
2 did not specifically address or refer to the zero tolerance policy. Okay,
That's correct.
Right,
One of the concerns I have and why I answered Justice McKenna's question the way I did was because when you read pages 6 and 7 of the intermediate court's decision, Judge Leonard points out, you know, this is more than enough to provide cause to have her terminated. So that's why I'm in the position where I kind of feel that I have to fight the entire battle.
Yeah, but that's not the notice your client was given. When the charges were given and the charges sustained, 8.10 only went to charge 25.
I agree, Judge. Justice Nevins.
Isn't that a due process notice issue if it's going to be pushed that way?
I agree. It is a due process issue. And one of the points that I wanted to make in terms of due process is if you, according to the intermediate court's decision and the circuit court's decision, the department director has the sole and exclusive authority to determine what sufficient cause is with respect to discipline for excluded employees. And the Merit Appeals Board, according to the intermediate court and the circuit court, had to defer to the department director's decision. Then if that's the case, as you pointed out, Justice Devens, the circuit court and the intermediate court deprived the petitioner and anyone after her a meaningful opportunity to be heard before the Merit Appeals Board under the Mauna Kea Idaho case. Because what are they appealing? What can they appeal? If the Merit Appeals Board is supposed to defer to the department director, then why even have an appeal? And I would point out that in terms of Chapter 76, 76-47B requires the Merit Appeals Board to apply the merit principle. And part of, or a subset or part of the merit principle is the just cause, which was the decision or the conclusion reached in the Kono decision.
Counsel, didn't the circuit court actually concede that if 8.10 was out, that the judge would have to defer to the Merit Appeals Board in that case?
Yes.
Wasn't that part of the opinion?
Yes, you're right.
So one thing though, that what presents as I think, most interesting question in this case is that we're focusing on charge 2, but there were 21 charges substantiated by the Merit Appeals Board of the, 48 charges that it reviewed. 21 charges were substantiated, and there were numerous other charges of sexual harassment as to other individuals as well that were substantiated. So let's just put the no tolerance policy aside for a moment. Those other charges were under ADM.03.13, right? Is my understanding of the record, which also doesn't reference a zero tolerance policy, but specifically says that this type of conduct, bless you, this type of conduct is subject to corrective action up to and including immediate discharge. I think the ICA also references that. And so the interesting question here from a statutory construction and statutory authority issue is, what is MAB's, the Merit Appeals Board's obligation with regards to such a policy? In other words, which clearly states that the employer can discharge where there are violations of this policy.
So when you look at the policy, volume 3 of the record, docket 38, page 168, that's the first page of the policy. The first page of the policy in the top in terms of the purpose uses the word guidance. It says that in terms of this particular policy, it is a guidance. Now, you're right. I agree with you. It does say later on that disciplinary action may be taken. But primarily, if you look at that, it is supposed to be a guidance according to the department. Now, this goes back to the argument of 46 dash, the point about 46 dash 47 regarding policy, methodology and administration. And I submit that in terms of reviewing a discharge or reviewing the appeal of a discharge, that has nothing to do with those three words as they're commonly defined.
Well, Hawaii Administrative Rules 14-25.1-4Y, which is, I think, adopted pursuant to 7647C, says that the Merit Appeals Board shall not impinge on the authority of the director in matters of policy. How does that play in here?
Thank you for asking the question. That was one of the points I forgot to bring up.
Thank you.
76-11 defines director as the DHERT director. Oh, sorry, that's me, my timer. Sorry. 76-11 defines department director as the director of the Human Resources Department, not other department directors. And I submit that when you look in paramateria, what Chapter 76 says, and also 26-5, it does not allow and does not permit, there is no rule, there's no regulation, there's no statute that allows the DHERT director to delegate his or her authority to the different department directors, because that would defeat the whole entire purpose of consistency and uniformity, which the legislature thought was imperative. And I would note that now I'm in my reserve.
You have 10 more minutes, so if you can carry on if you want, or actually had a question. In your view, could and I realize your argument is that the workplace the workplace nonviolence policy isn't in the record. And interestingly, when it's quoted by the circuit court, I think it refers to has a reference to immediate termination, I believe. You're not aware, was that actually immediate discharge? Was that part of the policy, or do you actually not know what the policy said?
Number one, I don't know what the policy is, Your Honor. But number two, what the circuit court was citing was the summary. And that summary appears, as I mentioned earlier, on the Record on Appeal, Volume 4, Docket 40, PDF, page 18. That's the summary that the department submitted. And if you look at the circuit court's decision where it's cited in the record, Forbes, I think it was 0060, that's the summary that I referred to earlier. So
go ahead, I'm sorry.
No, so my point again was that the circuit court was only citing a summary.
Okay, could the director of public safety have adopted a zero tolerance policy for workplace violence, which, if appropriately structured and spelled out what the consequences would be, and that consequence would be termination? Could that policy be entitled to deference under the statute as a matter of policy, methodology, and administration, such that principles of progressive discipline would not apply? Is that possible, or is your argument that no matter what the director established as a policy, the director cannot deprive the employee of what you would view as their right to a just cause determination by the Merit Appeals Board?
That's a separate brief that I could write on.
Yeah, I'm interested in how far your principle goes.
The Kono decision talks about not only just cause, but also talks about the duty of the employer to consult with the appropriate union regarding any changes in terms and conditions, including policies. The record in this particular case, when Mr. Ishibashi testified, and he was the HGA business agent, and I'm sorry, I can't find the reference right now, but Mr. Ishibashi testified that at no time, and based on the HGA's record, was there any record that the state of Hawaii or the Department of Public Safety consulted with respect to adopting this zero tolerance policy that appears at 08.10. That's the first thing. The second thing is, based on the constitutional Article 16, Section 1 of the Hawaii State Constitution, I do not believe, or I submit in this particular case, that that's a constitutional right in terms of the merit principle, and the merit principle does incorporate just cause. And given the statutory construction that excluded employees who are discharged may appeal that discharge, the decision to discharge, to the Merit Appeals Board, I submit that you can have a zero tolerance policy, you can discipline an individual for violating the zero tolerance policy, but in terms of the statutory construction, it is within the Merit Appeals Board's discretion or scope of duties and responsibilities to determine whether or not that decision was made according to the merit principle, which would include just, just cause.
So are what you're saying is that, modifying an action, let's say 60 days versus discharge, is not actually making policy?
That's correct, Your Honor. I am saying that.
Okay.
Because the policy is adopting the policy, the zero tolerance policy. I would agree that that's certainly policy, methodology, or administration. What we're focusing here on is the decision that the appellate review of the decision to terminate. The decision to terminate is not a policy, certainly not a methodology or administration.
So in other words, what the Merit Appeals Board does is it decides a couple things. One, substantiated or not substantiated. Two, what the possible consequences might be. So under 7647C, is it your position that we couldn't have agencies going out here and just making zero tolerance or even graduated, requirements that this merits a 5-day suspension, this makes a 60-day suspension? That would be intruding on the authority of the Merit Appeal Board.
That's correct, Your Honor. I agree with that, and it also would violate the merit principle and certainly the uniformity and consistency that the legislature has always sought with respect to public sector employment law.
And with respect to the merit principle and promoting the efficiency of government service, does the just cause standard and the progressive discipline principle, do those promote the efficiency of government service?
I believe when I read the statutes, Chapter 89, Chapter 76, there's actually divergence. Judge Watanabe and Mr. Halverson helped shepherd through Act 253 in the year 2000. And what they tried to do was, and now as employers, you have to do that performance appraisal form, and that's a direct result of that. And there's a certain administrative judge, or it's a different analysis. It's a different analysis, a different structure. The just and proper cause doesn't apply to that. Just cause would only apply to discipline. So there is a dichotomy when you read the statutes in parliamentaria. The efficiency issue and performance appraisals, they hire some kind of administrative judge or something to do it. They have a different standard with respect to, I'm going to discipline you, Ted Hong, because you're an incompetent, lazy employee. That's something different. And then if I'm now going to say, and we're going to terminate you, Ted Hong, because you crashed your state car into, a traffic light in the midday, that's something different in terms of discipline. So I submit that the two concepts are different based on the statutes.
Real quick, Mr. Hong, it seems like you're arguing, kind of conflating those employees who are under collective bargaining as opposed to those who are excluded employees, such as Ms. Forbes. I mean, isn't there a difference? Shouldn't there be? Isn't there a difference under this? I mean, 89C is what we're dealing with here, right? Not 89.
That's correct. And my client was a civil servant. I mean, if you look at, for example,
There's no question about that.
Okay.
Right? and merit principle, no question. I think I'm just hearing you speak to collective bargaining, which is not specific to the excluded employee in this circumstance, I think.
You're correct. And if I'm grieving on behalf of the UPW or an
Right.
HCA employee or firefighter or anybody else within the state or county system, just cause is negotiated. That's part of the collective bargaining agreement.
Right, specifically in a lot of the collective bargaining agreements, explicitly.
You're correct. And for excluded employees, when you look at the language in 89C and incorporating the merit principle, when you look at the executive order that we pointed out, that I pointed out, 03-1, and you look at even Act 253, the legislative intent, the conference committee report that I cited earlier, it all incorporates the concept that excluded employees, as a result of discipline decisions or specifically discharge, should have the similar opportunity to appeal. So in the Chapter 76, for example, excluded employees who are disciplined would follow the internal complaint procedure and go up the chain until the Merit Appeals Board. So the process, how you get there may be different, but the analysis would be the same, is what I'm trying to say.
I'm sorry, a collective bargaining employee goes up to the Merit Appeals Board?
No, I'm sorry, collective bargaining employee, and I misspoke, I apologize. The collective bargaining employee does go through the grievance arbitration process. I'd be happy to answer any further questions in rebuttal. Thank you.
Thank you, Mr. Hong, for your argument. Ms. Guilano, your argument.
Chief Justice, Associate Justices, Yana Guilano on behalf of the state. There are 21 substantiated charges here, and many of them are for egregious violations of the harassment policy. And to return to something that's been kind of mentioned, the state did not include copies of many of the policies for environmental reasons, but stated it would make those policies available upon request. So it wasn't a choice to leave the policies out, to not reference them. It was a environmental choice.
Sorry, the 10-page policy?
That was the choice that was made at that time. So I also would like to mention that those policies were publicly available. And so here, the Merit Appeals Board exceeded its statutory authority by disregarding the applicable policies here. The applicable policies, not only the zero tolerance workplace policy, but the harassment policy. And the harassment policy specifically states that departmental discipline shall be designed to correspond with the severity of the offense. And you can see that at ICA 38 at page 175. And the Merit Appeals Board did not apply that policy at all. And those were directly applicable to the substantiated charge number 2, which was in unwanted physical touching constituting sexual harassment, and then the sexual harassment of multiple other departmental employees. So whether or not the court agrees that the zero tolerance workplace policy applies to charge 2, and the state thinks it does, it constitutes violence. It was a physical assault. Whether or not the court agrees with that particular
But
policy.
3.13 is actually corrective action, right?
Sorry?
3.13 is in the corrective action section of the policies, right?
3.13
8.10 is the, which was not sustained, was
was the
zero
workplace
tolerance.
violence.
But
yeah.
you know, you say that the MAB exceeded its authority, but I'm reading the statute and it does say that the board may modify the action of the appointing authority if it finds the circumstances of the case so require, and may thereupon order such disposition of the case as it may deem just. And didn't the MAB also refer to the progressive discipline policy, a general concept, you know, progressive discipline?
Sure. I mean, the general concept of progressive discipline, however, it failed to apply the directly applicable policies, which it is statutorily obligated to do in that same statute, in that same section, 7647. So all of these provisions must be read together.
But 3.13 does not require discharge, right?
3.13
Up to discharge.
up to discharge, and part of that policy states that the discipline shall be designed to correspond with the severity of the offense. And in this instance, the Merit Appeals Board did
You're
not.
saying that the MAB exceeded its authority. Exceeded its authority.
It was obligated to apply the departmental policies, the applicable departmental policies.
So if the department creates a zero, let's say that the department creates kind of a ridiculous zero tolerance policy, you know, like you shall never make a personal phone call at work while you're on work hours or something like that. The MAB could not review that to see whether that was just pursuant to the statute.
Whether that policy fits with the principle of the merit principle is a separate question as whether the MAB must apply those policies. So in your instance, the question is whether that complies with the merit principle, which is, taking all of Chapter 76 together, whether it does for the efficiency of a government purpose, for the government service and appropriate employee action. So that's a separate analysis at which the MAB did not apply here. It did not consider, and its question was whether the MAB could consider whether the policy was sufficiently supporting the merit principle, or whether that is a question that's reserved for the circuit court. But that was not a question that was raised here and is not before this court.
Did I hear you argue that the workplace nonviolence policy is implicated in charge 2? Because that's not what Director Espinda said when he wrote the letter of November 13th to Ms. Forbes. It says charge 2 cites the DHERD policy, and then it also cites admin policy 3.2. It does not cite to the workplace nonviolence policy.
Yeah, I acknowledge that the charges on November, like the charge letters do not link charge 2 with the workplace nonviolence, but the actions themselves constitute workplace violence.
Does 2 have an intent component to it, like 25 did?
The applicable part that the state reads is that physical assault against employees will be regarded as an act of violence, and it doesn't necessarily imply any intent there.
I mean, 2 and 25 are different. You do acknowledge that, right?
Yeah.
And I think primarily because 25 deals with intent and fits into the zero tolerance policy, right?
So the two was the intentional physical touching of the department employee. 25, my understanding of charge 25 was a separate incident. There was also allegations of her pointing and yelling.
But that was the one that directly lined up with the zero tolerance
That
policy,
was the one that the department identified as.
Now, let me get back to the zero tolerance policy. Is it your position that every agency can simply impose zero tolerance policies, or even, let's say, +5 policies where consequences are imposed, and therefore the Merit Appeals Board has to follow those policies, which would include consequences? I mean, wouldn't that just simply neuter the Merit Appeals Board?
Well, the Merit Appeals Board may still analyze those for compliance with the merit principle. So yes, departments are allowed to create policies to ensure that their employees are behaving appropriately and are, effectively serving the government. Where what the question here is whether those policies support the merit principle is different from whether the Merit Appeals Board can change the consequences where there are certain circumstances. But whether they can change the discipline is a separate question, as they must first apply the applicable policies. And within that policy, they may then change the consequences.
Isn't that what they did?
The Merit Appeals Board did not apply the workplace harassment policy. It didn't acknowledge that there were, multiple charges.
Didn't find count two, substantiated count two, right?
Yeah, substantiated count two
In what
was,
sense didn't they consider the policy if they substantiated the count based on the policy?
it substituted what it called progressive discipline instead of applying what the workplace harassment policy that stated.
That says up to termination, correct?
Certainly it says up to, but
Up
it
to,
also.
not automatic.
Yeah, but
Up
it
to.
sure, but it also states that discipline shall be designed to correspond with the severity of the offense. There is no discussion of the severity of the
25
sexual.
was not sustained, which included the intent, the zero tolerance, and you did not appeal that.
No, so the part that I'm reading from is related to the harassment policy, which is 313.3.2, which is the applicable, as this
Are
court
you
has
saying that the progressive discipline policy is not a policy?
the progressive discipline is a policy choice made by the Merit Appeals Board, but the Merit Appeals Board,
Isn't that kind of built into civil service?
in the sense that the Merit Appeals Board may apply that policy, sure, but it must apply that policy within the context of those
So
directly.
my understanding is that this employee had no prior discipline. Is that right?
That is my understanding as well, yes.
And what happened was there were charges spanning the court over a year that were brought all at once, correct?
I believe that is correct.
Why
yes.
couldn't the MAB then say progressive discipline should apply here? There were no priors. Perhaps if some had been adjudicated earlier, maybe there would have been some sort of discipline short of discharge. The employee might have had an opportunity to receive additional training or, harassment training and know that it seems pretty obvious that this type of activity is not tolerated, but in any event, would have had a chance for progressive discipline.
Well, I think the issue here is that the Merit Appeals Board did not apply the harassment policy. It did not consider.
You're basically saying that the Merit Appeals Board has to follow the director, no matter the director of who? Public safety, not the director of human resources.
Right. The director of human resources has delegated certain policy making choices to the
So different
agencies.
departments can have different harassment policies?
As long as they comply with the merit principle, yes. There may be certain
So
circumstances.
certain departments can eliminate a harassment, then only federal law would apply then?
There may be circumstances in which an agency decides it doesn't want to have a harassment policy. And there's no requirement that there's a harassment policy. Each agency is allowed to determine what is appropriate employee behavior and create policies to regulate that. And the merit principle does not require that they be uniform. It simply requires that they uphold the merit principle.
So is it your contention that the board didn't adequately explain its reasons? I'm trying to understand, because I'm reading their decision. It says the board finds there are substantiated reasons to discipline appellant. And of course, they imposed a 2-month suspension, which is you would agree is a serious sanction, correct?
I mean, these are serious.
I understand. I'm
So-
trying to understand the argument you're making. Appellant's actions herein do not justify the imposition of the severe sanction. Are you just disagreeing with their outcome, or are you saying they didn't explain it well enough, or both?
So, I mean, the state has maintained throughout this process that the Merit Appeals Board did also exceed its discretion in making this decision. However, kind of returning to like the issue here is that the discrimination and harassment policy.
Is it sorry, go ahead.
Sorry, the discrimination and harassment policy requires that the discipline for any of those substantiated charges correspond with the severity of the offense. And yes, here the Merit Appeals Board did not consider the severity of the 21 substantiated charges, which included what was a sexual assault. of an employee.
But what brings you to that conclusion? That they didn't consider that? I mean, they had
They
it all
did
in
not
front of them.
articulate there's no articulation of any consideration of the severity of the charges that was substantiated. It counted how many charges were substantiated and counted how many that were not, but it didn't acknowledge at all that many of the substantiated charges were egregious violations of the harassment
isn't it,
policy.
I mean, do they have to have special words in there, or is it sort of implicit?
Well, in this instance, it didn't acknowledge the policy at all. It substituted its own progressive discipline policy when it considered what discipline was appropriate here. It did not acknowledge that there was applicable policies that were violated.
But under what they can do, and under the policy, it's 0 to discharge, right? And is your argument really just an abuse of discretion that they didn't discharge the employee, and you just basically feel that they abused their discretion because 60 days, didn't fit the case outcome? Is this just an abuse of discretion argument?
No, our argument is that it failed to apply the policies, which it was statutorily required to do. So it exceeded its authority by failing to
You're
do
saying
so.
it exceeded its jurisdiction? I'm really
No,
confused.
not
What
its
standard are you saying that the appellate courts are supposed to apply here?
So G2 considers whether the Merit Appeals Board exceeded its statutory authority or its jurisdiction.
You're talking under 91.
We're 91G2,
Yes, okay.
yes. So we're specifically talking about its statutory authority. And
The statutory authority allows it to consider these circumstances. does it
the
not?
statutory authority allows it to modify discipline, but that statutory authority also, that same statute also requires that it defer to the director on questions of policy, methodology, and administration. So where it did not apply the directly applicable policy,
Which policy?
both the workplace nonviolence one, but also the discrimination and harassment policy.
In what way didn't it apply it? It substantiated charges based on that policy.
It substantiated charges, but then it didn't further apply the provision that states it must consider the
Severity.
discipline must, yes,
But-
correspond with severity.
So your answer to Justice Edens' question is yes. Your argument is basically they blew it. This is really bad conduct. No reasonable person could conclude that a 60-day suspension is appropriate. When you really boil it down, is that your argument?
Yes, it's two layered. One, it didn't apply, and the applicable one required them to apply this, and they abused their discretion in
But the
not.
board did apply corrective action. It acknowledged the policy and it acknowledged that corrective action was part of the policy, and it just simply disagreed with the severity of the disciplinary action. Isn't that what it boiled down to? And it exercised its statutory authority to modify as it saw the circumstances called for it.
It did not consider the severity of the substantiated
How can you say that when it went
charges.
through the whole contested case hearing and heard all the evidence?
It said nothing about the severity of the substantiated charges. It lumped the substantiated charges as substantiated charges. It lumped unsubstantiated charges as unsubstantiated charges.
Yeah, but it also did say that they didn't find the intent to cause harm. So they did consider the severity.
In one instance, but there were.
But that's the same conduct that applied to other charges. It just didn't find the intent to cause harm.
But
So it
the
did
intent of-
consider the severity.
But the severity of inappropriately touching an employee.
Right, it
without
says they
his-
don't find credible evidence of that.
But they did substantiate the fact that that was sexual harassment.
Not to the extent that you folks were alleging. And you didn't appeal that.
It substantiated charge 2. It substantiated charge 2
But not
under
25. 25 was much more severe
25 was
in
a
my
different
mind because
charge.
it involved intent to cause harm.
25 was a different charge, and my understanding of the charge is that it's a different
It arose
act.
from the same conduct as charge 2 involving Mr. Castro. That's what the record reflected. If I'm wrong, correct me.
There were different acts. There were multiple acts against that employee. And whether charge 2 was substantiated or not, charge 25 was substantiated or not, charge 2 was substantiated, and it was substantiated under the discrimination and harassment policy. And because the Merit Appeals Board did not apply this policy, it exceeded its statutory
In what sense
authority.
didn't apply it? I'm sorry. It found she had violated the policy. That was the nature of the charge, which cited to the policy. They found they had violated it.
And then it exceeded its discretion by
So
not
would you have-
considering the,
I'm so sorry. No, would you, I mean, so the sentence reads, while the board here finds there are substantiated reasons to discipline appellant, if they had added substantiated reasons based on egregious conduct to discipline appellant, you wouldn't have a problem?
the department would still maintain that it was an abuse of discretion,
Okay,
and
so-
considering the facts,
So
it
it's
was an abuse of
two-pronged.
discretion.
One is it didn't
yes.
explain itself adequately, and the other
Yes,
is
essentially.
respectfully, we disagree.
Yes, and the abuse of discretion part has not been thoroughly discussed or considered.
So the ultimate
below.
disposition you're asking for is for this court to impose the discharge.
Is to
It's
affirm.
not
the
to
circuit court.
remand it back
No,
to the Merit Appeals Board to further explain its reasoning.
no, the state's request is to affirm the circuit court's, reinstatement of the discharge. If the court disagrees, then the likely scenario would be to remand to the Merit Appeals
Now,
Board.
wasn't
to-
that outcome that you just detailed throughout your briefing premised on the notion that there was a violation of 8.10, which results in the automatic termination?
That was the grounds that the circuit court reversed the Merit Appeals Board and reinstated the discharge, and that's what's been carried forward. But the state initially did challenge the discretion of the Merit Appeals Board in its first appeal to the circuit court. So in the instance that what has proceeded from the circuit court has focused in on the basis of the circuit court's ruling, the state maintains that there are other reasons that the Merit Appeals Board erred.
But now that it seems clear to us at least that the charge 25, the most serious charge, the charge that under the zero tolerance policy, regardless if it was introduced in evidence, regardless of if the MAB even has to follow a zero tolerance policy, that was the only thing that resulted in an automatic termination, right? So
That was-
again, is under 7647C, isn't it the Merit Appeal Board's kuleana to take a look at the whole thing and decide whether under the merit principle, under the statutes, that the consequence or that was imposed was just or not? And they decided that it was not just, and I just can't, I don't see any way where you're just not arguing this is an abuse of discretion by the Merit Appeals Board.
Certainly, that was the alternative argument, which was raised before the circuit court, and again, hasn't been thoroughly addressed by the ICA because the circuit court decided the matter on the application of the zero tolerance policy. So the state does maintain that there was an abuse of discretion here. But whether that can be decided here,
But isn't that based on, the Merit Appeals Board actually took live testimony, right?
my understanding is that they did, yes.
And so are you then arguing that the Merit Appeals Board was clearly erroneous in setting aside 25? I'm confused.
Not 25, no.
Okay, so you're not arguing that.
I'm not arguing with respect to charge 25, respect to
I'm
the
just kind of
substantiated
curious.
charges.
Is there maybe, when they consider the merit principle, do they consider the merit as to other similar types of charges? Like how other similar cases are handled in civil service? What kind of discipline has resulted from other sexual harassment or sexual assaults within DPS or other departments? Is that maybe allowed to consider that?
I'm not prepared to answer that. I'm not sure that was quite kind of before this court and before as a question, but it's certainly part of its kind of body of knowledge. It could consider that.
They have the expertise to consider what type of discipline or progressive discipline is imposed in similar situations across the state, right?
If it had articulated that it had considered that, but it didn't articulate what it considered, it simply
But
said
they did
apply.
refer to progressive discipline.
Simply progressive discipline
Okay.
with respect to specifically the substantiated, not substantiated charges and applicants' employment history, but did not specifically discuss the very egregious substantiated charges.
I'm sorry. I was just gonna ask, did DPS, did they use the just cause standard when they terminated the employee?
I'm not sure. The DPS did state that it was discharging the applicant because of the charges that it brought and because that, one second. let me
So,
pull up
so
the-
it would seem that, they are basing their decision on just cause.
Certainly.
And it seemed that the ICA also recognized the just cause standard. Is that right?
It recognized that just cause in the sense that there was a articulated policy, substantiated charges in violation of that policy. So in that sense, there was just cause for Forbes'
And
termination.
would you say that the just cause standard aligns with the merit principle?
So the just cause standard in what instance? A applicant is championing this 7-step analysis, which has not been acknowledged by these courts here, or the Merit Appeals Board even. The Merit Appeals Board did not apply this 7-step standard. So in the sense that just cause simply means that there was an articulated policy and the employee was terminated for substantiated, violations of that policy, that just cause standard, yes, applies.
Mr. Milano, I wanted to just go back to the circuit court's order, and the circuit court's assessment was that, and this is pretty much a quote, paraphrasing a bit, progressive discipline for most of the charges the board found were substantiated by credible evidence, including hostile and offensive work environment, sexual harassment, ancestry, national origin, race and religion, yelling, swearing, keeps going on, long list, could be imposed consistent with DPS admin policy 13.3. Were these the only charges at issue, the court would be required to defer to the Merit Appeals Board's expertise and experience and not substitute its own judgment for the agency. It cites Dole versus Ramil. And then the court goes on to talk about the violation of 8.10, but we've established that 8.10 is the one charge that, or one of the charges the board didn't substantiate. So under the circuit court's own framing of the issue, progressive discipline was appropriate for all these other charges. And you're in essence arguing, and the circuit court said, I would be required to, I shouldn't substitute my judgment if that's all it was.
In the
You know,
state,
you understand the passage I'm referring to,
I
right? So
do.
you would violently disagree with that.
I would vehemently disagree.
Okay.
And
Vehemently violent, yeah, no violence. Strongly
no workplace violence here.
Strongly disagree.
Yes, I would disagree. And the state had noted that it disagreed with that circuit court statement on page 16 of its answering brief, I believe, footnote 5.
Right.
It noted that it disagreed with that finding. And so therefore, to that extent, the state would like to preserve that argument.
If this court were to rule in favor of Ms. Forbes, what does the department believe the remedy would be here at this point to affirm the MAB?
The remedy, if the court were to completely agree with Ms. Forbes, would be to affirm the MAB so that the state could then challenge the MAB's findings itself.
How?
On the basis of these claims that we've articulated, the
If this
abuse of
court
discretion.
affirms the MAB, what challenge would there be?
Well, so as I've mentioned, the state has maintained that the MAB violated or, abused its discretion. And the ICA did not address that issue. The ICA addressed the issue that the circuit court had.
Would this court not be able to address that?
Well, the state has not had an opportunity to more thoroughly brief that the abuse of discretion question, as it was not addressed in the ICA. And it was not the subject of the question before this court here.
All right.
Wait, I'm sorry, what issue are you saying is still preserved and could be appealed later?
So the passage that Chief Justice Rechtenwald mentioned from the circuit court stated that it would have been within the Merit Appeals Board's discretion to change the discipline. And the state has maintained that that's inappropriate and that was incorrect.
As a cross appeal?
No, because it essentially
I know
wanted.
you object, but has that been,
It has not been cross-appealed, no.
isn't that gone then? How would you raise it now? I'm just trying to figure that out.
At this time, I could not tell you what the proper procedural process would be, but the state has maintained that finding, it was incorrect, and that was not quite what was on before the ICA, so it was not considered fully.
Thank you.
Okay,
Anything further at this time for the
if there are
court?
no other questions, thank you.
All right, thank you for your argument. Mr. Hung, I think you only had a little bit of time. If you need another minute or two, you can have it, but please keep your remarks brief.
Very brief. May it please the court. The Igawa decision versus Koa House Restaurant, 97 Hawaii 402, pages 409 through 10, basically says in a secondary appeal of an agency decision, the weight of the evidence, the courts declined to consider the weight of the evidence, passing upon the credibility of witnesses or conflicts in testimony. When they talk about egregious offenses and all these other things, at this level of the secondary appeal doesn't apply. The second part is, in terms of progressive discipline, that is one of the 7 factors of just cause. We had articulated those 7 factors in the opening brief to the Intermediate Court of Appeals. That's docket 76, and it lists the 7 different factors at PDF pages 21, 22, 23. One of those factors, the last factor, is the progressive discipline issue. So when the Merit Appeals Board talks about progressive discipline, it wasn't just standalone progressive discipline. It was part of and parcel of a 7-step test.
Well, counsel, let me ask you, because 3.13 uses the term corrective action. Isn't that implying progressive discipline because you progress to correct? It's a structural approach to correct behavior?
I agree. I think you're correct. And when you, again, this is in parliamentary, you're kind of looking at Chapter 89, 89C, Chapter 76. This is all kind of an amalgam of different employment laws. I would just point out very quickly that in terms of Chapter 76-47C, about the policy, methodology, administration issue that was brought up, again, when I read the Chapter 76, I don't see that and I don't believe the state has articulated any reason for the the Human Resources Department has any authority to delegate that authority down to the different department directors, which goes along the lines of, I think it was Justice McKenna's and Justice Evans' concern about consistency. And then finally, we would ask the court to reverse the Intermediate Court decision, summary disposition order, reverse the Circuit Court's decision, and reinstate the Merit Appeals Board's decision. Thank you for your time.
Very well. Thank you to both of our attorneys for your arguments here today. The court will take this matter under advisement.
Eku Iluna, please rise. Ua ho'oku'u ia mai nei kea aha ho'okolo ki hano o ka moko aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.